Welcome, curious minds, to another deep dive. Today we're tackling, well, a really fascinating and complex legal challenge coming out of Trinidad and Tobago.
It really is.
We've got a stack of sources here that paint quite a vivid picture, actually, of a long-running employment dispute. Our mission, as always, is to dig into the crucial insights, try to clarify some murky waters, and hopefully deliver those aha moments for you.
Moments that help make sense of it all.
Exactly. We're looking at a situation involving RBC Royal Bank, TNT, Ltd., and their estate constables. And at the heart of it, serious allegations of unlawful retrenchment and employer misrepresentation. Now, our source material for this deep dive is pretty unique. It's basically like listening in on a detailed legal strategy session. You had this individual, Victor Sandy, asking these really critical, pointed questions about the case.
And we're here to sort of unravel the legal complexities behind those questions. It's a deep dive into the mechanics of industrial law, really. What's truly fascinating here, I think, and what we really want to illuminate for you today, is how the legal landscape is, well, designed to adapt, even to new discoveries that pop up years after something first happened.
Yeah, like years later.
Yeah. This deep dive really highlights the power of, sticking with it, persistent inquiry, and the nuances, the layers of industrial law, how legal rights can actually persist even when, on the surface, it looks like too much time has passed.
It feels like a story about the dynamic nature of justice, almost.
It is. New facts can genuinely rewrite the narrative.
So what does this all mean for the workers affected? Many have been out of work for, well, over a decade now. And for you, listening, trying to understand your own rights, if you're facing, say, corporate restructuring or these complex legal fights.
Yeah, what are the takeaways?
Let's unpack it. We're going to walk through the initial allegations first, then tackle that big question. Is it just too late to bring up these new issues?
The time-barring question, always crucial.
We'll unpack the specific legal citations, the Trinidad and Tobago case law that actually backs up the constable's position. Then we'll get into the nitty-gritty, the powerful new evidence that seems to have surfaced recently.
The paper trail.
Exactly. And finally, we'll look at the complicated role of the Estate Police Association, the union, and the path forward for these officers to take independent action. It's quite a journey through the legal system.
Driven by some very pressing questions.
Let's get started. Okay, to set the stage, let's start right at the heart of it. What exactly are the core allegations against RBC Royal Bank, TNT Ltd., about that 2015 retrenchment of their estate constables? The media reports and the legal memo we have are pretty direct. What went down back then?
They are blunt, yes. The formal legal memorandum, which was submitted to the Integrity Commission of Trinidad and Tobago, alleges, quote, procedural and legal irregularities. Basically, that the way RBC handled the retrenchment back in October 2015 was flawed. But the central issue, the really striking one, and maybe the biggest aha moment in this whole thing, revolves around the use of this undefined and unregistered entity. It was called Enterprise Service.
Enterprise Service.
And this entity was supposedly used to carry out the terminations, but the allegation is it did so without any proper legal authority, which right away, that's a massive red flag in industrial law.
Why is that?
Because the entity actually doing the terminating, it has to be a legally recognized employer itself, right? It needs the legal capacity, the standing, to take such a serious step against employees.
So if I'm hearing you right, the core problem could be that the terminations were issued by what you might call a phantom employer. That's a pretty big claim.
Phantom employer is a good way to put it for our listeners, yeah. It captures the essence of the allegation.
So where does it get really interesting? What were the specific key allegations laid out in that memorandum? This feels crucial for understanding the whole foundation of their legal challenge.
Absolutely. The memorandum outlines 4 critical points that really form the bedrock of the constable's case. Let's break them down.
Okay.
First, the big one, no lawful employer transfer. The sources state very clearly there's just no evidence. Zip. No consent forms signed by the employees, no amended contracts showing a new employer, no official notices saying, hey, you now work for Enterprise Services.
Nothing like that.
Nothing. And think about it, if your job gets transferred to a whole new company, there's usually a mountain of paperwork. You'd know about it. You'd likely have to agree to it. Without that clear legal transfer, the argument is you're still technically employed by the original company.
So RBC would still be on the hook.
That's the argument, because a legal transfer needs clear documents and often employee consent. Without it, the original employer usually keeps all the responsibilities.
Okay, that's allegation 1. What's next?
Second, related to the first, is the fictitious employer role. The claim is that Enterprise Services isn't shown to be a real legal entity, at least not one with the power to hire or fire people.
It's not just about the name, then.
Not at all. It's about legal personality. Can something that doesn't legally exist or isn't registered as an employer actually act like one? The memo argues no, and basic employment law supports that. If true, it could make the terminations void from the start.
Invalid right out of the gate. Okay. What about the person who signed the letters? Did they have the authority? That seems like another potential weak spot.
You're right. That leads directly to the third key allegation, questionable authority. The termination letters were signed by a Mrs. Anissa Elham Hussein,
Okay.
but her specific role, and more importantly, her authority to act for this new, maybe undefined employer, Enterprise Services, was apparently never established. Who was she acting for? What gave her the power to issue those critical letters on behalf of that entity, especially if the entity itself lacked legal standing?
Huge questions of agency there.
Exactly. If she wasn't properly authorized by a legitimate employer, those letters could be invalid.
Okay, that's 3. What's the 4th?
Fourth, and this is significant too, is statutory noncompliance. The whole retrenchment process, they allege, failed to follow the mandatory rules set out in the Retrenchment and Severance Benefits Act, the RSBA.
Chapter 88.23.
That's one. It lays out a very clear procedure for how retrenchments must be handled to protect workers. Things like mandatory consultations with the union, a cornerstone of fair process in TNT, and proper formal notice procedures.
And the allegation is they didn't follow these rules.
Allegedly, yes. If that framework was ignored, the whole process could be seen as procedurally flawed, maybe illegal, even separate from the who's the employer question. The RSBA isn't optional. It's a legal requirement for fairness.
So if you tie all these threads together, it sounds like a potential breakdown in following the law, leaving these constables in a kind of legal limbo, still technically RBC employees because no one with authority lawfully terminated them.
That's precisely the implication, yes.
Yeah.
If these allegations hold up, it means they might never have been lawfully terminated by a valid employer.
And if that's proven true, what's the potential outcome for these constables? After all this time, what could they actually get?
The potential remedies are substantial, really profound if the claims are proven. It could mean reinstatement, getting their jobs back, as if they'd never left.
Wow.
Plus, back pay, wages for all the years they've been out of work since 2015, that could be a very significant amount.
Huge.
Then pension restoration, making sure their retirement benefits are whole, accounting for all those years of service as if they'd never been interrupted. Critically important.
Absolutely.
And finally, damages for wrongful dismissal, compensation for the unlawful way they were terminated, covering losses, maybe emotional distress. It's a full package aimed at putting them back where they would have been.
This isn't just a technicality then. It hits right at the core of job security and employer responsibility. Could be millions in liability for the bank.
Potentially, yes. The financial and legal implications are enormous if these allegations are substantiated.
Okay, but here's the elephant in the room. This all started back in 2015. We're talking about it now in 2025. That's well over 11 years.
A long time.
Right. And one of the first things Victor Sandy asks, and I bet a lot of you listening are thinking this too, is basically, it's been over 11 years. Is it too late? Is the time barred passed to bring up this issue with the bank? What does the law in Trinidad and Tobago say about a delay like that? Is there a statute of limitations that just slams the door shut?
It's a critical question and often where these things get complicated. But under Trinidad and Tobago industrial law, whether a claim is time-barred isn't just about how many years have passed. It's crucially about when the facts, the information giving rise to the claim, were reasonably known, or when they could have been discovered if someone was being reasonably diligent.
Okay, so it's not automatic.
Not automatic. And this is a really key difference from many civil claims, which often have very strict, fixed deadlines that expire no matter what.
So what's the specific rule in industrial law there?
Well, the first and maybe most surprising point for many is that there's no strict limitation period under the Industrial Relations Act, IRA, Chapter 88.01. The sources are clear on this. Unlike many civil claims, the IRA itself doesn't set a hard deadline, a fixed expiry date, for bringing industrial disputes.
Really? No fixed limit at all?
Not in the statute itself for bringing a dispute to the industrial court. It means the clock doesn't just automatically run out after, say, 6 years or 10 years, just because the dismissal happened long ago. The thinking behind it is to allow for fair resolution of these complex relationships, prioritizing justice over rigid timelines.
Okay, no automatic deadline. That's surprising. But surely you can't just let cases drag on forever. Courts don't usually like that, do they?
You're absolutely right. There are safeguards. While there's no strict cutoff date in the Act, industrial law does address delays. Rule 4.6 of the Industrial Court Rules comes into play here.
Rule 4.6, what does that say?
It allows the court to strike out a case for what it calls inordinate and inexcusable delay. But here's the crucial part. That delay must also cause prejudice.
Prejudice, meaning harm to the other side.
Exactly. The key words are prejudice and inexcusability, not just the simple passage of time. For the court to throw out a case using this rule, the other party, RBC in this instance, would have to actually show that the delay has genuinely hurt their ability to defend themselves.
How would they show that?
Maybe key witnesses are truly gone. Maybe crucial evidence has been irretrievably lost because of the delay, and that the delay itself was inexcusable by the claimants. It's quite a high bar. Courts generally prefer to decide cases on their merits unless the delay creates real, demonstrable unfairness.
So the clock doesn't just run out. But what about this new information? This whole enterprise services issue seems to be a recent discovery, right? Even though the case is 11 years old. Does finding something new like that effectively restart the clock or maybe create a whole new avenue?
Precisely.
Yeah.
And this is where the principle of new legal issue discovered, new cause of action becomes absolutely vital. It's a real game changer. The issue of who the actual employer was, RBC, or this undefined entity, might represent a separate, or what lawyers call a latent cause of action.
Latent, meaning hidden.
Hidden or not reasonably discoverable earlier, the legal idea is crucial. The
Sure.
right to bring a claim, the cause of action, doesn't always start on the day of the dismissal itself. It can start when the breach or the fraud was discovered, or when it should reasonably have been discovered.
Like finding a hidden defect years later.
Exactly like that. It draws on common law ideas used in fraud cases, where the limitation period often doesn't begin until the fraud is actually uncovered. So if this whole misrepresentation about enterprise services was genuinely hidden, or only became clear after a recent careful review of documents in 2025, then the cause of action for that specific issue could be considered new. It essentially creates a fresh opportunity to challenge it.
Okay, and does the court have flexibility to allow this new issue in, even if the case has been going on for so long? Yeah.
Yes, absolutely. And this is another crucial safety net. The industrial court keeps significant discretion to allow new legal issues to be raised, even late in the game. Rule 6.2 of the Industrial Court Rules allows this if the issue is material, meaning important, genuinely newly discovered, and relevant to achieving a just outcome.
Rule 6.2.
This rule lets the court ensure justice is served, even if it means adjusting the case to include critical new facts that weren't known before. It really emphasizes the court's focus on fairness over strict procedure, especially when new evidence pops up that could fundamentally change the picture.
So the bottom line here is pretty significant for the constables, isn't it?
Yeah.
If this misrepresentation about the employer's identity was genuinely unknown until recently, like 2025, then raising it now is not time barred.
It appears to be the strong legal argument, yes.
That really does change the game, doesn't it? It suggests that even after all this time, a fundamental flaw, if newly discovered, could totally alter the case's path. It gives them a renewed shot at justice.
It absolutely does. This new discovery principle means time alone, without knowledge of the problem, can't necessarily shield the other party from accountability. The focus shifts from when it happened to when the crucial information about its legality actually became available. It's a powerful legal pathway.
Okay, that's a critical understanding of the timeline issue.
Okay.
But, in law, principles need backing. Specific legal authorities, precedents. So the natural next question, and one Victor Sandy directly asked, is, are there any citation to rely on? For anyone facing a legal fight, having that solid legal foundation is everything. What specific laws or rules support bringing this issue up now?
Right, you need the legal anchors. And the sources do provide a pretty robust framework here, citing several key authorities. We've already touched on the bedrock principle. The Industrial Relations Act, IRA, Chapter 88.01, has no specific limitation period built into it for bringing these disputes.
That's the starting point.
That's fundamental.
Yeah.
It means the 11 years passing doesn't automatically kill the claim just because it's old. It keeps the door open, legally speaking.
Okay, what else?
Secondly, we go back to Rule 4.6 of the Industrial Court Rules. We mention it regarding delay. It's critical because it says the court can only strike out a case for inordinate and inexcusable delay causing prejudice, not just age.
The emphasis is on prejudice, the harm caused by the delay.
Precisely. The party claiming prejudice, RBC here, has to prove it. Show actual disadvantage like lost witnesses or evidence directly because of the delay, and show the delay wasn't justifiable. This principle is backed by higher courts in Trinidad too. It stops cases being tossed just for being old unless there's real unfairness.
So the bank can't just say too long, they have to show actual harm.
Got it.
What about the legal support for this idea of new evidence resetting the clock?
That brings us back to the latent cause of action and discovery rule. This is a core legal principle. It states that the right to sue accrues, or starts, when the claimant knows, or reasonably should have known, out the wrong.
Especially if something was hidden.
Exactly. If evidence of misrepresentation, like using enterprise services incorrectly, was concealed or only surfaced recently, the legal clock for that specific issue might only start ticking upon discovery. It treats the discovery of the hidden wrong as the trigger point.
Okay.
Then there's Rule 6.2 of the Industrial Court Rules the court's discretion to end. This is huge. It gives the court broad power to allow parties to amend their case or bring in new legal issues if it's just and in the interests of justice.
So the court can allow them to add this new argument.
Yes, it's a key procedural route. It lets the officers formally introduce this newly discovered employer identity issue into the existing case, even after all this time. The court's main job is justice, and this rule gives it the flexibility needed when crucial new facts emerge late. It's a vital tool for fairness.
Is there anything else? What about the initial step of reporting a dispute to the Ministry of Labor? Does that create a time issue here?
That's a good practical point because that's usually the first step.
Mm-hmm.
Section 59 of the IRA normally says a dispute should be reported to the minister within 6 months.
6 months. That sounds like a potential problem.
It could seem like it, but the law anticipates situations like this. The legislature gave the minister broad discretion to extend that 6-month limit if fairness requires it, especially in complex situations or where facts weren't known.
So discovering these new facts now could justify the delay.
Absolutely. The recent discovery of fundamental new facts, like the whole employer identity question, can definitely justify why that specific aspect wasn't formally raised or reported earlier within that initial 6-month window. It shows the system has built-in flexibility, again focusing on fairness over rigid timelines, especially when critical information was missing at the start.
Okay, so putting it all together, no strict time limit in the Act, the need to prove actual prejudice from delay, the power of newly discovered evidence, and the court's discretion. It sounds like raising this employer status issue now against the bank is legally solid.
It appears to be legally permissible and procedurally valid, yes. The conclusion seems clear based on these authorities.
That's a powerful position for the constables to be in, giving them a clear path forward that might have looked completely blocked off before.
It definitely solidifies their ability to pursue this crucial part of their claim. The legal framework in Trinidad and Tobago seems designed to ensure that substantive justice can prevail, even if the full truth takes years to come out.
Okay, we've got the legal principles, the rules, the statutes. But how does this stuff actually play out in court? Victor Sandy quite practically asked, are there any cases in Trinidad and Tobago to refer to? Are there specific local precedents, actual decisions from Trinidadian courts that strengthen these arguments? This is where the theory really hits the road, right?
Exactly. Case law shows how these principles are applied in real life, and the sources do point to several highly relevant Trinidad and Tobago cases that directly support the constable's position on both the delay issue and the core allegations about RBC.
Great, let's hear about them.
Okay, the first one, and it's probably the most foundational for the employer identity issue, is 1. Oilfields Workers Trade Union v. Super Industrial Services Ltd. from 2006. An industrial court case.
Okay, OWTU v. SIS.
Yeah.
What did it establish?
It established a really critical principle. A worker's actual employer depends mainly on who has control and who represents themselves as the employer at the time of termination. It's not just about what the formal paperwork says or doesn't say.
So control is key, more than just the name on the letter.
Precisely. In that SIS case, the company was found to be the legal employer because it exercised the real control, even if the formal transfer documents weren't perfect. The court looked at the reality of the relationship.
How does that apply here?
Its relevance is huge. If RBC kept controlling the estate constables, setting their duties, managing them day to day, handling their pay, their pension, even while trying to say Enterprise Services fired them, this case strongly backs the argument that RBC was still the legal employer.
Because they held the reins.
Exactly. It directly supports the claim that the termination by Enterprise Services was void because Enterprise Services wasn't the real employer exercising control. It's a cornerstone for their whole argument.
Okay, that's a powerful one. What's next?
Next up, a more recent one. 2. Transport and Industrial Workers Union v. ANSA Polymer Limited. This went to the Court of Appeal in 2021. It built on an earlier industrial court decision.
ANSA Polymer 2021. What's the principle there?
This case strongly emphasizes the court's flexibility, their willingness to allow amendments and new arguments, even late in the proceedings, especially if it serves the interests of justice. The Court of Appeal really reinforced this idea.
That sounds directly relevant to bringing up the Enterprise Services issue after 11 years.
It is, spot on. Its relevance here is that it directly supports making new legal submissions, like the employer status issue, even late in the day. ANSA Polymer confirms the industrial court's power and discretion under that Rule 6.2 we talked about to make sure all relevant issues get heard. It prioritizes fairness, even in long-running cases.
So it counters any argument that it's just too late to add this new point.
Exactly. It gives the constable strong legal precedent to argue for, including this critical new evidence and argument.
Okay, what else?
Then there's 3. Jorsing v. Attorney General of Trinidad and Tobago, a high court case. Now, this one is interesting because it actually condemned extreme delays in litigation.
Condemned delays, how does that help?
But here's the nuance. While the High Court stressed the need for timely justice, it didn't say that delay automatically prevents a claim. It emphasized efficiency, yes, but not at the cost of automatically killing a potentially valid claim. A 10-year delay in that case was called unacceptable, but wasn't necessarily fatal.
So it's like a warning shot about delays, but not a brick wall.
Precisely. Its relevance here is that it helps counter any simple defense of delay from the bank. It shows courts dislike long delays, but their main focus is still on ensuring justice is done based on the case's merits. It supports the idea that even with a delay, if it's justifiable, like due to new discovery and doesn't cause irreversible harm, the case should proceed. Efficiency matters, but justice matters more.
Okay, one more.
Yes. 4. Transport and Industrial Workers Union v. Public Transport Service Corporation. This one's fascinating because the court talks about societal corporate inertia.
Inertia. What does that mean here?
The court noted in that case how persons have been acting for upwards of 10 years without having their position regularized. It's a recognition by the court that sometimes things just drag on, especially in large organizations or complex collective situations, and it's not always the worker's fault.
So the court understands that delays can be systemic, not just one party dragging their feet.
Exactly. Its relevance is that it further supports the argument that courts recognize and sometimes account for these systemic delays. It suggests long-running issues don't automatically wipe out rights, especially if new facts come up or if the delay is partly due to the complexity of the corporate or union structure itself. It adds weight to the argument that the constable's case shouldn't be tossed just because it's old, especially with this new information.
These cases together sound like a really strong legal toolkit for the constables.
They provide a powerful arsenal, yes. They show that Trinidad and Tobago courts seem willing to prioritize substance over strict timelines, especially when new, important facts emerge or when fundamental justice is at stake. It's about fairness and getting it right, not just ticking boxes.
Okay, so the whole strategy seems to hinge on this idea of new discovery. That's the linchpin, right?
It really is.
And Victor Sandy, clearly understanding this, asked for a document outline as proof the officers can take these steps due to the new discovery. So what specific evidence, what kind of documents actually form the backbone of this new discovery, and why is each piece so critical? Let's get into the real nitty-gritty now of the paper trail.
Absolutely. The outline in the sources details the factual basis for calling this new evidence. Evidence that was apparently only properly reviewed and its significance understood in 2025, a full decade after the 2015 retrenchments. This timing is key to overcoming any time bar arguments. It wasn't just missed, it was uncovered later.
Okay, so what's the first piece?
First, you have the letters signed by Mrs. Anissa Alham-Hussein referencing enterprise services. These are ground zero. They are the documents that actually claim this entity. Enterprise services was the one doing the terminating.
The letters themselves are evidence.
Yes, the very fact they exist and attribute the termination to this entity, which is now being questioned as potentially dubious or non-existent, legally forms the basis of the misrepresentation claim. They're the tangible proof of the alleged phantom employer narrative being used.
Okay, so the letters point to the problem. But what about things that should be there but aren't? Is the absence of paperwork also evidence?
That's the second critical piece, and often just as powerful. The lack of documentation evidencing a lawful transfer. This means a glaring hole where legally required paperwork should be.
Like what?
Like signed consent forms from the employees agreeing to move, formal contract novations, new contracts replacing old ones with a new employer, official notices clearly stating a transfer from RBC to some other entity. Legally, if there's no paper trail for a transfer, it generally means no proper legal transfer happened.
So the void itself speaks volumes.
Exactly. It's not just missing documents. It's evidence that a necessary legal step was skipped. It directly challenges any claim by RBC that a legitimate transfer to enterprise services ever actually occurred.
Okay, letters pointing to the entity, lack of transfer docs. What else?
Thirdly, internal RBC communications. These could be gold. Documents showing that RBC itself, not some separate enterprise services, was actually calling the shots, directing the officers.
This goes to that control test again.
Precisely. Proving who really held the lanes. Internal emails, memos, reports, these often reveal the true operational reality behind the official story. They show who was making decisions, giving orders about these constables.
Okay, let's dig deeper into that internal evidence. Victor Sandy specifically asked, evidence of internal RBC control. What is high T? What specific types of documents would prove RBC kept control, showing they were the real employer all along, despite the enterprise services story?
Right. This is about finding the specific proof points that satisfy that control test from the OWTU VSIS case. What shows RBC was in charge? Okay, first, potentially the termination letters themselves, especially if they were on RBC letterhead. The sources mention letters from October 19, 2015, signed by Jeremy Jones, an RBC figure. Even if the text mentions enterprise services or enterprise operations, the fact they might use RBC's official logo, their letterhead.
Aye.
That immediately shows RBC controlling the communication, being the visible authority.
Like putting their stamp on it, even if they blame someone else?
Kind of, yes. It links the action directly back to RBC's identity.
Okay, what else?
Second, actual RBC internal communications. We're talking emails, memos involving key RBC managers like Roland Ketton, Manager Protective Services, Superintendent J.A. Jones, Michelle Gonzalez. If these docs discuss internal decisions about the constables, their jobs, assignments, performance, the termination plan itself, it directly shows RBC management making the calls, not some separate entity. It reveals who was pulling the strings.
Makes sense. Internal discussions.
Third, organizational charts or payroll records from RBC. Documents showing these estate constables listed under RBC's security structure right up until dismissal. And crucially, no record of them being shifted or reclassified under a separate enterprise services unit in HR or payroll systems. If they stayed on RBC's books internally, that's strong evidence no real transfer happened.
The internal structure didn't change.
Exactly. Fourth, again, the absence of employer transfer notices. No consent forms, no novations, no official transfer letters. This lack of legally required paperwork is itself evidence confirming RBC kept control because the steps to give up control weren't taken. Evidence by omission.
Okay.
Fifth, work assignments and daily supervision logs. Things like duty rosters, shift schedules, assignment memos issued by RBC security managers, directives coming from known RBC departments, not some independent operation. This shows who controlled their day-to-day work, a core part of the employer control test. If RBC told them what to do each day, it's hard to argue they weren't the employer.
Daily control. Got it.
No.
Anything else?
Finally, post-retrenchment actions by RBC. This is interesting. Did RBC issue pension statements after termination, records of employment, ROE, other correspondence? If RBC continued to handle these administrative tasks typically done by the former employer of record, it undermines the idea that enterprise services truly took over. It suggests RBC still saw them as their former employees.
So all these pieces together paint a picture of RBC still being in charge, contradicting the enterprise services narrative. Very compelling.
It builds a strong circumstantial case based on RBC's own potential documents and actions, or lack thereof.
Now, there's another piece of evidence Victor Sandy highlighted, and it sounds particularly potent. It's about their pensions. They are still holding the pension trust, which was started in our initial employment. What's the big deal about this? Why is the pension trust so legally significant? Could this be the smoking gun?
It's arguably one of the most critical pieces of evidence, yes. It strongly suggests RBC remained the employer of record the whole time, making the enterprise services claim look very questionable, perhaps even deliberately misleading.
Why is it so critical?
Okay, 3 main reasons. First, it shows continuation of the fiduciary employer role. If RBC is still holding, managing, administering the pension trust set up during their employment, it's a powerful affirmation that RBC never legally cut ties as the employer.
Why? Can't anyone hold a pension trust?
Generally, no. Under Trinidad and Tobago's Income Tax Act and typical trust rules, only the official employer of record can maintain and administer such a trust. RBC continuing to do this is a direct, ongoing sign of their employer status. It's a legal and financial obligation only the employer usually holds. Hard to explain away.
Okay, so it ties them legally as the employer. What else?
Second, it points to a potential violation of RSBA termination obligations. Remember the Retrenchment and Severance Benefits Act. It sets out specific duties for an employer when they terminate staff, especially regarding pensions.
Like what?
They usually have to finalize the benefits, maybe transfer the accrued funds, or properly wind up the trust and release the money or claims to the employees. If RBC didn't do any of that and just kept holding the trust, it's strong evidence the termination itself wasn't finalized legally according to the statute. The employment relationship wasn't properly severed.
So the termination process itself was incomplete.
Potentially, yes, leaving RBC still connected. And third, it links directly back to that control test for employer status from the OWTU v. SIS case.
How so?
That case established that the entity controlling core benefits, like pensions, is strongly presumed to be the employer. The fact that enterprise services apparently never took over this crucial fiduciary duty, never managed the pension, reinforces the argument that no real legitimate transfer of employment actually happened. It suggests enterprise services was just a name, not an entity taking on the real responsibilities of an employer.
Wow. That makes the pension trust a really powerful, tangible piece of evidence, a continuous thread tying them to RBC. Okay, next question Victor Sandy raised seems simple, but maybe it's not. All signature on the retrench letters are photocopy. Is that legal? Are photocopied signatures on something as critical as a termination letter a legal problem in Trinidad and Tobago?
It might seem like a minor detail, but you're right, it can be legally significant. It goes to the document's validity and authenticity. Under T&T industrial and contract law, photocopied signatures on crucial documents like retrenchment letters can raise serious questions, especially in termination cases where due process is absolutely paramount.
Why are photocopies potentially problematic?
Well, firstly, retrenchment requires official authorization and authentication. The RSBA requires written notice, properly authenticated. A photocopy, without an original signed document somewhere to back it up, or maybe a clear statement confirming its authenticity, might not meet that standard.
It lacks proof it's real.
It raises doubts, especially if there's no certificate saying this is a true copy, or if the person signing, like Mrs. Alham Hussein or Mr. Jones, wasn't actually authorized to sign for the legal employer. It opens the door to challenging whether the termination was truly issued by someone with the proper authority and intent.
Okay. Any legal precedent on signatures?
Yes. Secondly, regarding legal precedent on signature authenticity, Trinidadian courts generally require signatures to show clear intent and authority. A mere photocopy, without an original available or clear proof of the signatory's authority, could be challenged as invalid under evidence laws and contract principles. The court needs to be sure the person whose name is there actually authorized that specific letter.
So it's not just a formality.
Yeah.
And thirdly,
the lack of an original signature can be a procedural defect. In the industrial court, an unauthenticated or just copied termination letter could be deemed voidable, especially if it can't be proven it was properly issued by a lawful employer, isn't backed by original proof, or was part of a process that lacked proper steps like consultation. It could be argued it's just one more sign of overall procedural sloppiness, casting more doubt on the retrenchment's validity.
So it's not just a technicality. It hits the core question of whether the termination was legally sound. Okay, one last piece of documentary evidence. Victor Sandy mentioned a specific payslip, saying, the payslip is critical legal evidence. What makes this particular payslip so important? It sounds routine, but clearly it's not.
This specific payslip, issued by RBC Royal Bank, T&T, limited for the period October 16th to 31st, 2015, literally days before the termination letters went out, is indeed highly significant. Its power lies in providing direct, potentially undeniable proof of who the employer was right at that critical moment.
How does it do that?
Okay, firstly, it explicitly shows RBC as the employer of record. The company field on the payslip clearly states RBC Royal Bank T&T Limited. But here's the crucial bit, the real aha moment. Enterprise Operations is listed merely as a department or an internal unit within RBC, not as a separate company or legal entity.
Just a department name.
According to the payslip, yes. This directly confirms that Enterprise Operations was internal to RBC, flatly contradicting any claim that employment was lawfully transferred to some external, independent enterprise services entity. It's RBC's own document showing their structure.
Wow, okay. What else makes it significant?
Secondly, its proximity to the retrenchment date is absolutely key. It covers the exact half month when the termination letters were issued. This direct timing proves the employees were paid directly by RBC immediately before getting those notices.
So they couldn't have already been transferred.
It strongly refutes any claim they were transferred before dismissal. If RBC was still their paymaster right up to the end of October, they were still RBC employees at that point.
Makes perfect sense.
Yeah.
And thirdly,
it's undeniable proof of control and payment. Only the official employer of record issues official payslips and handles payroll. This document confirms RBC maintained payroll control right up to termination. And as we keep saying, based on that OWTU v. SIS case, payroll control is a fundamental test of who the employer is. This single payslip is powerful, unambiguous evidence that directly challenges the enterprise services narrative.
it's hard to argue you're not the employer when you're issuing the payslip right before the termination.
Exactly. It creates a very difficult position for that narrative.
So these pieces of evidence, the letters, the lack of transfer docs, the internal comms, the pension trust, the photocopied signatures, and this payslip they combine to create a really compelling picture challenging the bank's actions, don't they?
They collectively paint a picture suggesting noncompliance, misrepresentation, and continued control by RBC, significantly strengthening the constable's arguments. It provides the concrete new discovery they need to move forward even after all this time. It's the tangible proof grounding their renewed legal challenge.
Okay. This deep dive has uncovered some really potent legal arguments for the officers, building a solid case on this new evidence. But, there's another layer of complexity here, a procedural hurdle that seems to have really complicated things for them.
Yes, the union involvement adds another dimension.
Right. Victor Sandy brought up the Estate Police Association, the EPA. He mentioned them registering 42 officers in the original case without their consent, and also a significant delay, almost 300 days, in getting the case referred to the industrial court initially. So he asks, can it be a separate matter, seeing that the officers never gave the Estate Police Association permission to represent them, or the new issue have to be raised when the case is call again? Basically, after 11 years, can the officers now pursue this separately, challenging what the union did back then?
Yes, they potentially can. Under the Industrial Relations Act, IRA, and the Industrial Court's procedures, this situation can indeed allow for a separate independent action, provided certain conditions are met. This area of law, where individual worker rights intersect with union representation, is crucial.
How does that work? What are the grounds?
Well, the first ground is fundamental. No consent. No lawful representation. If the EPA really did act without the express or even implied consent of those 42 named officers, then legally the union might have acted ultra vires.
Ultra vires, meaning?
Beyond their authority. Think of it like someone filing a lawsuit in your name without ever asking you. While the IRA does give a recognized majority union, RMU, like the EPA power to represent workers for collective bargaining generally, that power doesn't automatically stretch to launching individual legal disputes or naming specific people in court actions without their direct permission.
So collective bargaining is different from individual court cases?
Yes. The law distinguishes between the union's broad role and needing a specific mandate for individual grievances or court referrals involving named individuals.
Okay, lack of consent is one ground. What about the delay?
Secondly, that delay of 297 days could be statutory noncompliance. Over 9 months between getting the unresolved status letter and actually referring it to the court is a very long time in industrial relations, especially if it happened without the workers knowing or agreeing. Such a long, potentially unexplained delay could be argued as unreasonable, breaking the chain of proper representation.
Allowing them to argue the original referral was flawed.
Potentially, yes. It could give them grounds to say the union didn't act diligently or with proper authority, enabling them to raise the employer identity issue independently now.
So given these potential flaws, lack of consent, long delay, how do the officers actually proceed? Can they file a whole new case?
They have a clear path. Yes, they could potentially file a new dispute or a set of individual applications based on two strong arguments. Ground A would be procedural irregularity, defective representation, the argument. The original referral to court was made by the EPA without legal standing or our consent as named officers. This challenges the very legitimacy of how the case started for them.
Okay. And ground B?
Ground B is the new cause of action, employer identity misrepresentation. This brings in all the new evidence we just discussed. The argument. The termination process falsely used enterprise services, a non-existent or unauthorized entity, and we only recently discovered this misrepresentation or fraud. This allows a fresh challenge based on these newly uncovered facts.
So they could start fresh. Is there an alternative? Could they fix the existing case?
Yes, there's an alternative. If they prefer not to start a completely new case, they could file a Rule 6.2 motion within the existing proceedings.
That rule again.
It allows them to formally ask to intervene or amend the current case. They'd argue the EPA didn't have authority to represent them and ask the court to rehear or adjust the case to specifically include this critical employer identity issue and the new evidence. It offers some strategic flexibility.
Okay. That distinction between the union's general power and needing individual consent is key. But Victor Sandy clarified this further. He said, the EPA is the recognized union to represent estate constables, but B didn't ask then to represent USD and industrial relations officers to represent us. But he didn't. He represented the EPA who registered the 42 officers without their consent. Does the EPA, being the recognized union, override the need for individual consent here?
That clarification is incredibly important. And the answer is generally no. It doesn't automatically override it for this specific type of action.
Explain that.
While the EPA is the recognized union, giving it rights under the IRA for collective bargaining for everyone in that group, that authority does not automatically extend to representing specific named individuals in an industrial court dispute without their informed instruction and consent. This is a vital protection for individual rights within the union structure.
So the RMU status doesn't give them a blank check for court cases involving individuals?
Not for naming individuals in a dispute referral without their mandate, no. The union has to act on their specific instructions for that. Individuals can challenge the union acting ultra vires beyond its specific authority for that action. It's about agency.
And what of the industrial relations officer, the IRO, representing the EPA, not the officers?
That fact that the IRO apparently represented EPA and not the 42 officers directly further strengthens the argument that the referral wasn't based on the workers' personal instructions. The IRO was acting as a union's agent, not necessarily theirs.
So the implication here is pretty huge. The original referral might have been procedurally invalid because it named people without their consent?
It creates a significant procedural defect right at the start, yes.
I mean, if the officers weren't even properly represented in the first place.
That's the core of their argument on this point. And it allows them to claim several things now. 1, no lawful termination due to the fraudulent employer identity issue, backed by the new evidence. 2, no lawful representation binding them in the current EPA case. And 3, a clear right to an independent hearing or relief, because the original process involving them was flawed from the outset.
This really opens the door for them to act independently, doesn't it?
It provides compelling reasons for them to seek their own path forward, yes, with their own chosen legal counsel.
Okay, this is a critical point for these constables. They seem to have strong grounds to challenge the termination, the representation. But then there's a practical roadblock. Victor Sandy laid it out. The lawyer will have to get authorization from the EPA, and the EPA does not want to give that authorization. What should we do? What happens when the official union refuses to greenlight representation for the very workers it's supposed to represent? Especially when there's powerful new evidence the union isn't acting on. That sounds incredibly frustrating.
It is a frustrating situation, and unfortunately not unheard of. But importantly, under the Industrial Relations Act, IRA, in Trinidad and Tobago, workers are not left without options in this scenario. There's a specific legal procedure to bypass the union in these kinds of exceptional circumstances.
An escape hatch.
Exactly. An escape valve to ensure access to justice isn't blocked by the union itself. The key is Section 23, 1, and 2 of the IRA.
Section 23. What does it say?
It explicitly states that a worker may appear in person or be represented by an agent before the court. This is the fundamental principle giving individuals direct access. So if a recognized union, like the EPA here, fails to act in a worker's interest, or importantly, acted without authority in the first place, the workers can ask the industrial court for leave that means permission to proceed in their own name.
They can represent themselves?
They can appear themselves, or they can ask the court under Section 23(2) to appoint an agent or representative for them, which explicitly includes their own chosen lawyer. So if the designated driver, the union, won't drive or goes off course, the law lets you take the wheel yourself or get another driver.
Okay, so how do they actually do that? What's the immediate practical step to get this permission, bypass the EPA, and have their own lawyer recognized by the court?
The essential step now is to file a motion seeking leave. They need to formally file a motion for leave to proceed independently of the recognized union.
What would that motion argue?
It would argue several points. One, we never gave consent for the EPA to include us in this case initially. Two, the EPA is now refusing to authorize representation for us to pursue these critical new issues. Three, these new issues, the employer identity, the pension affect us personally and materially, and we need to address them directly. And four, fundamentally, justice and due process require an independent hearing for us, as we can't rely on the union.
Do they need to provide proof for this motion?
Yes, crucially, they need an affidavit by affected officers. Each officer, or maybe a lead officer representing the group, should swear under oath that they were never consulted by the EPA before being named, they don't authorize the EPA now, and they explicitly want to appoint their own representative under Section 23. That personal sworn statement carries a lot of weight.
Is there case law supporting this move?
Yes, that ANSA polymer case we discussed earlier, again, supports the court's broad discretion to allow representation outside the main union when justice demands it. It backs their right to make this motion.
Now, Victor Sandy did mention they took a step already. We sent this letter to the industrial court already. What's the legal effect of sending that letter to the registrar? Does that accomplish anything?
That's an excellent question. Sending that letter was a significant first step. It acts as a formal declaration of non-representation and disassociation. It has real legal weight, especially with officer signatures.
How so?
Well, first, it's a formal denial of agency. It tells the court, the EPA doesn't have our authority to act for us or bind us in this matter. It nullifies the EPA's standing regarding these specific officers.
Okay.
Second, it serves as a disassociation from the proceedings. It asserts that any outcome in the existing EPA case rulings, settlements can't apply to them unless they explicitly agree in writing. It protects them from being stuck with an outcome from a process they didn't authorize.
A protective measure.
Yes. And third, it's formal notice to the registrar. The court itself is now officially aware that these officers claim their names were used without a proper mandate. This puts the court on notice to scrutinize any further reliance on the EPA's representation for these individuals. It creates a flag on the file, essentially.
So the letter lays the groundwork, puts everyone on notice. What's the immediate next step to make this separation official and let them proceed with their own lawyer?
The immediate next crucial step is to file that formal motion for leave to proceed independently under Section 23 of the IRA. The letter was the declaration. The motion is the formal request to the court to act on that declaration and grant them official standing to proceed independently or through their own counsel. It turns the statement into a court-sanctioned reality.
Okay, one final, very practical question Victor Sandy asked. Are we bypassing the Ministry of Labor by filing this motion directly with the industrial court, since normally disputes go through the ministry first?
That's a key procedural point, and the answer is yes. For this specific procedural step, asking for independent standing, they are bypassing the usual ministry referral route.
Why is that allowed?
Because Section 23(1)(2) of the IRA specifically allows workers to come directly to the court when they aren't being properly represented by their recognized union. This motion isn't about starting a new industrial dispute about the retrenchment itself from scratch that would typically need ministry involvement first for conciliation. This is about fixing a problem within an existing court framework, the problem of improper or unauthorized representation, and asserting their right to stand independently because of it.
So it's a specific exception for this situation.
Exactly. It's
Yeah.
a procedural correction. Now, it is important for you, the listener, to understand the sources clarify this too. If the court grants them leave to proceed independently, and then they decide to initiate a completely new dispute focusing solely on the retrenchment based on the new evidence, that new dispute would likely still need to be reported to the Ministry of Labor first, following the standard procedure.
Ah, okay. So this bypass is just for getting their own standing recognized by the court now.
Precisely. It's direct access for this specific purpose, allowed by the law to ensure workers aren't left without recourse when their union representation fails them or acts without authority. Hashtag outro.
Wow. What a deep dive, truly, into the very intricate world of industrial law in Trinidad and Tobago.
Yeah.
This case and, Victor Sandy's persistent questions driving this analysis, it really shows the power of sticking with something and really understanding these complex legal frameworks.
It really does. It's a testament to the idea that even after so many years, if new information comes to light and you keep digging, the path to justice can potentially reopen.
Yeah. This deep dive, I think, shows just how critical it is for anyone, for you listening, to understand your rights, especially when you're facing complex situations like, say, a big corporate retrenchment, or maybe even challenges with your own union representation.
Absolutely. The discovery of these latent defects, these hidden issues, the power of seemingly small bits of evidence like a payslip or pension records, and importantly, the court's ability, its discretion, to prioritize real justice over just rigid timelines. These are all powerful takeaways.
It can really shift the course of a long fight.
They absolutely can. It highlights that the legal system, well, it can adapt to new facts even years later, aiming for fairness.
So for you, our listener, we hope this deep dive serves as a compelling example. An example of how, even after a decade, crucial new information can fundamentally change the legal landscape. And how asking the right questions, backed by really meticulous research and understanding the law, can open doors to justice that might have seemed permanently closed.
That was the goal.
Our mission today really was to shortcut your path to getting informed on this specific, quite complex legal journey, complete with, hopefully, some surprising facts and those aha moments. We've seen how digging into the source material, into the details, can reveal profound insights and potential ways forward.
And maybe it raises a broader question for all of us, doesn't it? In this age of, well, information overload, where corporate stories can be carefully managed and complex situations can hide the key facts, how vigilant are you, really? How vigilant are we all in questioning narratives and scrutinizing the details, especially when our own rights, our own situations are on the line?
Are you willing to keep digging for the truth, even when the path looks long and maybe the odds seem stacked against you?
A question worth pondering.
Thank you for joining us on this deep dive. Until next time, keep digging, keep asking questions, and stay curious.